First District Court of Appeals, 9th session. All who have business before this court, draw near, give attention, and shall be heard. For God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have one case on the docket today, Guglielmo versus Zephyrhills Corrections Institute. Is the appellant ready to proceed?
May it please the court, my name is Megan Oliva and I represent the appellant Michael Guglielmo in the present appeal.
You might want to pull that mic a little closer.
Does that sound better, Your Honor?
It does.
Perfect. I'd like to reserve 5 minutes for a rebuttal. The primary issue in this case is whether the judge of compensation claims erred as a matter of law in concluding that Mr. Guglielmo's AWW, or average weekly wage, was $0.
I'm going to cut you off and jump into questions.
Okay.
I think we all probably have a lot. But just for some clarifiers, when were benefits initiated in the case?
So he initially filed a few months after his date of accident, and they, if I'm recalling correctly, chose to investigate under the 120-day rule not too long after that.
I didn't notice in the record any notice of action change or anything that would tell me when benefits were actually accepted. I know when the petitions were later filed, but just generally, was it the employer carrier started paying after he went to the hospital for the first time in March, or not until the ablation in July?
So
Or
once
until I guess the hospitalization or hospital visit in July.
they didn't pay any monetary benefits.
Right, but medical.
Medical, once he filed a notice of his injury, they authorized, I believe, Dr. Gerchek, who then ultimately recommended the procedure.
And that was, medical benefits were initiated before the ablation in December, so it's
Yes.
July, maybe even before that?
I don't have the precise date for you, but it was sometime shortly after he filed his notice.
Okay, thank you.
Yes. So on the date of accident, Mr. Guglielmo did go to the ER due to atrial fibrillation. As I stated earlier, the employer agreed to investigate the claim and they provide medical benefits. They ultimately decided to accept compensability of the atrial fibrillation, and then the issue of impairment benefits and the payment of lost wages came before the judge of compensation claims.
Now I'd like to sort of redirect your responses to the issue of the disability date and the average weekly wage. So as the claimant, you chose the date of accident, 7/16/21. Reason for that choice of accident, I would assume, is date of disability.
Yes, Your Honor.
So you concede that that's the first time that there were any wages lost or his ability to earn wages occurred.
Yes, Your Honor.
Okay, and I guess also, is it your position that disability is an element encompassed within the presumption category, or is it separate and apart? So, for example, you can qualify the factors for presumption under 112.18 that is separate and apart from the disability requirement in 441.51. Do you agree with that, or do you think disability is merged into the presumption?
No, I think there can be a difference. I think you can suffer disability without actually being entitled to, say, temporary total or temporary partial disability benefits. In fact, the statute says that you don't even get temporary total disability benefits for the first 7 days unless you suffer 21 days of disability, at which point they can go back and pay that initial week. So I think the disability referenced in 112.18 and the disability referenced by Chapter 440.
So the two, even though the word's identical in two different statutes, the definition in 440.02 can mean two different things?
I think it can mean two different things, especially.
How can that be?
Well, disability in the context of Chapter 440, I think, really involves the payment of temporary total and temporary partial disability benefits.
Well, that's not what the definition, I mean, the definition is more general, isn't it?
It is, Your Honor. But when it comes to Chapter 112 claims, I think the disability there's a lot more room for interpretation. So not only there, are, of course, if there's wage loss, there can be disability, but also if you were just unable to work as a result of that condition. So it's not necessarily tied
Well,
to
that
wage
is the
loss.
definition of disability under 44002, isn't it?
Right, but you can I think
So
you can.
then, you've just said the same thing for two different statutes, which is what my question.
So maybe I'm misunderstanding the question, but the point, I guess, that I'm trying to make is that even if there is disability under Chapter 112, which qualifies, which results in entitlement to that statutory presumption, that doesn't necessarily mean temporary total, temporary partial, or impairment benefits are going to be paid.
Sure, but doesn't that still, I mean, there's no claim under 112.18. 112.18 doesn't provide work comp benefits. It's a more general statute, but it feeds into, so if you get a presumption under 112.18, that in part you have to have suffered some sort of disability as a result of the impairment caused by the hypertension, heart disease, or tuberculosis, right?
Yes,
So if you get the presumption,
yes.
and there's compensability accepted, or there's a stipulation that the presumption applies, isn't that necessarily a statement that the worker is disabled? Which means a statement that the worker has lost the ability to earn wages for a certain period of time.
Yes, I agree, but I think, and especially in this case, I think the employer's acceptance of compensability under Chapter 112, just as opposed to an occupational disease or out of the goodness of their hearts, really demonstrates that they believed he was entitled to compensability of that condition because he satisfied those four elements, so which one of them is a covered employee. So
Well,
that was
more importantly, that he suffered a disability as a result of the impairment caused by the heart
exactly,
disease.
because absent that factor, there is no compensability under Chapter 112.18 because that disability element is central to entitlement to benefits under that statute.
Well, for clarification, is it your position that you have to satisfy disability for entitlement to medical, or is that just an indemnity component?
I think to be entitled to any kind of benefits under Chapter 112.18, you have to satisfy disability regardless of whether or not it's for indemnity or medical benefits.
And I think this kind of goes back to your clarifying to Judge Tannenbaum and myself, but is it your position that if an employer carrier stipulates that the presumption applies, that they do not have to show disability, that the employer carrier has conceded disability?
Yeah, that would be our position. I think the
Well,
parties.
let me ask you the facts here. So give us the timeline again, if you don't mind. Your client had not worked for the Department of Corrections for how long?
For a few months. So he worked for the Department of Corrections from June of 2019 to March of 2021. Then on July 16th is when he went to the ER due to the atrial fibrillation.
And he didn't work for anybody else in that 4 or 5 month period?
Correct. He did not. He was looking for employment, but his primary focus was
So-
his health.
Your argument is, under the statute, which defines the presumption in terms of a disability, then the employer carrier, by conceding medical benefits, has to concede that he was disabled for a certain period when he was not working?
I'm
So
not.
he was working, the date of accident, he was working or not working?
He was not working. He was not employed by the Department of Corrections on the date of accident, but it's our position that since they conceded that he was entitled to that statutory presumption, they effectively stipulated that he was an employee, even though he wasn't. I think the parties were all aware of the same facts. Obviously, a party can stipulate to whatever facts they want, and the judge has to accept it, absent, of course, fraud, misrepresentation, or something like that. And there were no findings of fraud or misrepresentation or anything like that
So
in
your
this
argument
case.
is you buy the medical benefits, you buy the whole kit and caboodle?
Yes, Your Honor, and I think that's consistent with the theory of workers' comp in the state of Florida, which is to compensate injured workers for their
And that
loss
kind
of
of holding
earnings.
by this court encouraged employers not to accept and agree to compensability under the presumption? Is that the policy that's would result from ruling in your favor?
No, Your Honor, I think the policy would be you should be careful what you accept.
That's my question. So
It-
if we hold in your favor, the policy, I'm not saying the state legislature didn't adopt that policy, but the policy implications of the holding are to employer carriers, whether government or non-governmental, be careful if you agree that somebody meets the presumption, you're paying for the medical benefits, and you have no defense to a disability claim.
I
That's
think-
your argument, right?
Yes, Your Honor. I think there are some exceptions to that, such as this court has found that if you don't report your wages for federal income tax
I
purposes.
noticed in your brief, you made it very clear that he reported all his income.
He did.
I think I wrote fast track, so I understand that. Fast framing.
Well, haven't we recognized, though, that you can have more than one date of disability? I mean, there can be more than one date of accident, which is a date of disability and occupational disease. I know we've got a 180-day limit for you to file these claims. You have to file a claim within 180 days of leaving employment. Here, it looks like 7/16/21 was 119 days, and so I'm sure you're counting. So you file a claim, you're looking at that clock, but the person may still be working. So no disability. So basically, the way you want us to interpret the statute is for the employer carrier to say at that point, if there's no disability, even though there's medical care for one of these conditions, it's denied, it's gone. The employer carrier says, not picking it up, and that claim's gone.
Well, I think in the context of Chapter 112.18 claims, yes, if the disability doesn't happen prior to leaving, I
think the question by Judge Thomas is, as I understand it, is let's assume let's assume your client was working on the date of the accident and being paid, but had atrial fibrillation and met the conditions. Well, I guess your argument is they couldn't meet the conditions of the presumption because they're not disabled. In that hypothetical.
Correct. If they didn't miss work, didn't lose any wages, there would be no disability.
If I mischaracterized your question, I apologize.
No, it's just that position's contrary to our case law in multiple cases where we have declared the presumption is separate and apart from disability under 151.
I'm not.
Bivens, Frierson, I could keep going. So
No.
you are asking us to change that position?
No, Your Honor. I think
Why not?
And maybe it's because I think oftentimes that it is favorable to my clients. And
Well, first tell us, if you don't mind answering Judge Thomas's question first, is your position contrary to that prior case law?
I'm not sure if I'm misunderstanding your question. I don't believe my interpretation, it contradicts the case law.
Okay, let me, and perhaps I can be more clear. So we have declared as a court multiple times that the elements to meet the presumption have nothing to do with disability. You check that list, pre-employment, physical, one of the categories of workers, et cetera, and so forth. So one can qualify for the presumption, but you still have to show as the first responder that you suffered disability in order to be entitled to benefits, medical or indemnity. That's
Yes.
what we've said.
Right.
Okay.
And I'm not disagreeing. And I think in this case, that disability element was satisfied, albeit after he left his employment. I think the case law, this is a very unique set of facts. One that at least I couldn't find any case with facts similar to it, where you have an occupational disease And obviously, in occupational disease cases, the injury or the disability can happen long after you leave your employment. And so I think there's a gap in at least the case law that I reviewed for cases where, say, somebody went on a 3-month vacation, or they're a teacher that has an occupational disease claim, but they didn't work the summer. And so just because they didn't work at all in those 13 weeks prior to their date of disability, per this judge of compensation claims, that would mean that they wouldn't ever be entitled to any kind of temporary total, temporary partial impairment benefits, permanent total disability benefits.
Well, we've got a case, Michaels versus Orange County, that addresses this issue, and we said in that case it was a firefighter's case. There were multiple disability dates. The issue was average weekly wage calculation. And in that case, the claimant wanted the older salary instead of the lesser salary, but we said no, it's the date of disability as in chronology, and that claim had been based on that later date of disability, so the average weekly wage is calculated on the circumstances surrounding that later date of disability. So we have sort of spoken on this, that you're declared, you assert the date of accident here, that date of disability is what we look at.
And I don't disagree. It's our position that there is a gap in the case law and the statute, if you will, for circumstances like this where the employee has already left employment. And if there are no further questions at this time, I'll reserve my remaining time for rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. To me, there are three distinct issues in this case. There's the issue raised by opposing counsel as to compensability pursuant to 1112.18 because the appellant is a first responder. He had 120 days after leaving his employment to file his claim, and it was a compensable accident, occupational disease, as Judge Arthur called it, the JCC. And
why did your client pick it up? I mean, when there was no disability, when that initial claim came in?
Well, we did the 120 days because when we first got the claim, we weren't really sure. All we knew, the carrier and I, as their legal representative, we only knew that he hadn't worked for the state of Florida, the correctional department, since March hadn't worked there for a while, and it took a little time. So initially it was accepted pursuant to the 120-day rule, and let's investigate. When I got all the information, when the carrier and I got the information, it was clear that 120 days had not passed yet. Pick it up, provide all the medically necessary treatment pursuant to the authorized treating physician, Dr. Kurzak. But
Where was the disability back when this started?
I'm sorry?
When you picked it up, where was the disability?
There was no disability.
So why'd you pick
Dr.
it up?
Kurzak, the authorized treating physician, never said that there was a disability, although I agree with the JCC that when he was in the hospital, I mean, clearly he was totally disabled and unable to work while he was in the hospital.
What makes you say that?
Because as an attorney, I rely on a medical opinion. In order for the claimant who has the initial burden, the appellant who has the initial burden of proof, they have to get a medical opinion saying that a injured worker is disabled. And in this case, there was no medical opinion that the appellant was disabled, and that's all there is.
You said it was obviously he was TTD when he was in the hospital.
That's true.
Why is that obvious?
But there was no medical opinion. It's obvious to me and to the JCC that when he was in the hospital, he was unable to work, and he was
Sure,
being
but he
treated
wasn't working.
with
I
medical.
thought the position of the appellee was, but he had already retired. He wasn't working. So how could there be a disability? Isn't that the position of your client?
He wasn't working as of March 20th, 2021. He wasn't working because he didn't need
he
to work
retired.
anymore.
Right.
He voluntarily resigned. He took his pension, and
So then why is it obvious that he's disabled if he's in the hospital, if he's not working? Taking your client's theory to its logical conclusion.
because the physicians in the hospital and in workers' comp, while emergency room physicians are not, their opinion is not admissible as evidence in workers' comp proceedings.
I think the question is, what does it matter? If he's not working, whether he's in the hospital, no offense to the claimant, whether he's in the hospital for brain surgery or whether he's in the hospital for a scuffed knee, if he's not working, legally he can't be disabled. That's your position in this case, right?
The reason it matters is whether he's disabled, is the reason that he's not working. That's the big issue here. And it changed. The reason that he was not working changed from March 20th, 2021, when he voluntarily resigned, and almost 4 months later, on July 16th or 14th, when the accident day is July 16th, so I'm going to use that date, when he went into the hospital for atrial fibrillation. The reason that he wasn't working started out for one reason, and then while he was in the hospital, in my experience, I would not dispute, it would be silly for me to dispute the fact that he was, and say, well, he was able to work. I could say, as a lawyer, I could say, they have to prove it with a medical
All right,
opinion.
so you acknowledge that you don't actually have to still be employed by your employer to be disabled?
When you're a first responder, definitely not. And
Well,
when
any-
the cause,
any
when the reason that
occupational
you're
disease.
not working is because of an injury that a compensable injury that you sustained while in the course and scope of
Right,
employment.
imagine any employee who suffers an occupational disease under 440-151. The occupational disease manifests itself and you suddenly become unable to earn wages sometime after you leave your employer, but the occupational disease is attributable to the work. Say you can prove it as a claimant, that is attributable to the work you did at your prior employer.
If the occupational
you can
disease.
still recover, right?
If there's a medical condition that was the major contributing cause of that medical condition was your work, with all the different potential repetitive trauma, exposure,
Sure.
all those different causes, if it was the work, it's a compensable disability.
Even if you've already left the employ of the place where you
Even
suffered the
if
disease.
you have a compensable injury,
Right.
you decide to move out of the state and there's no work available, and you have restrictions.
So based on that, assuming that you satisfy this, you can show that the occupational disease is attributable to your prior employer. And by definition, if you satisfy the elements under the occupational disease statute, which means that you suffer some disablement, how could the AWW ever be zero? Because then what would be the basis of saying that you were unable to earn a wage?
It can be zero because of the way the statute read and the basis for the statute. The basis for all the opinions with regards to, 13 weeks. If he worked substantially the whole of the 13 weeks immediately prior to the industrial accident, not a problem. In this case, he not only did not work substantially the whole, he did not have any customary hours. He was not expected to work at all. He had no expectation of earning incomes, and that is the most significant factor that I read in the case law,
So
is
he has
that
to testify.
expectation of earning income.
So he has to testify that he was thinking about working again sometime in the future, but now can't. That's your position?
And the case law has been very clear, and it's out there. I know you know it, it can't be just a speculative expectation. It has
Well,
to
then what's
be
the
a case
disability?
where they have a job lined up, and then they were due to appear and work their first shift on XYZ date, and at this time, and they couldn't because of this injury.
Well,
And that's not the case here.
In occupational disease cases, you cannot apply purely 44014. I mean, every time you've got to resort to D, which is the alternative, or you look at the occupational disease cases and you look at the circumstances at that asserted date of disability. So, what Judge Tannenbaum is saying is, you just said that you can reach back and attribute, your current disability to a prior on-the-job accident, but yet, on the other hand, conversely, you're saying, but you can't also look back to that average weekly wage. It's sort of a mutually exclusive position you're asserting.
No, what I'm saying is, if if this claimant had atrial fibrillation and he was unable to work, the main thing is he did work in the 13 weeks immediately prior, or put it the other way, he had not voluntarily resigned from his employment, and he had an expectation of wages coming in, he would be entitled to disability benefits if there's a medical opinion saying that he was disabled.
It seems like
I'm sorry?
It seems like your client is trapped in inconsistent views, that you accepted the disability based on the presumption, but you argue he wasn't disabled because he didn't miss any work. And I don't criticize your carrier or the employer. It seems like almost a Good Samaritan position, that you wanted to help. You saw this was a fairly serious medical condition. I assume the medical benefits were somewhat substantial. I don't know. But when you do that, under the statute, the only reason you do that is because they have a disability. The statute doesn't say if you're a firefighter or a corrections officer and you have a medical condition that doesn't cause any disability, you still get medical benefits. That seems to be the way you've applied it here.
Well,
Unless I'm missing something.
Okay. Well, we never accepted a disability. We accepted the medical condition, and we accepted the atrial fibrillation as an accident.
I think the argument, excuse me. I think the argument is you cannot accept the medical condition without accepting the disability, because the statute says in these certain covered occupations, if you suffer disability, it's presumed to be compensable, and you've agreed to, or it's assumed to be covered, and you've agreed to that, but you want to kind of cut the baby in half and not pay disability payments. I'm not sure the statute allows that.
I would say if there was a medical opinion saying he was disabled because of the atrial fibrillation, or and this...
Well, you thought he was disabled because you paid the medical benefits.
We'd never paid any disability benefits.
Okay.
We paid medical benefits. We
Maybe
provided medical
you could
treatment,
help.
and we will continue to pay medical treatment for as long as it's medically necessary.
So I think the disconnect here for us is that the presumption is separate and apart from your duty to provide benefits. The presumption only gives you that connection for causal relationship. You
Correct.
still, you being the first responder, still has the responsibility under 44151 to prove disability in order to be entitled to medical and indemnity benefits. So sounds to me like your position is that the presumption of 112.18 is separate and apart, and as long as those factors are checked, the first responder gets all benefits.
Well, it's complicated because there's two things. First of all, there's no average weekly wage. It's zero, although I will concede that statute 44015 does say that if he hasn't worked substantially the whole of the 13 weeks, if there is no similar employee, if there is no contract rate, then the judge should find a way that's reasonable and fair
Right, let me
to
switch
determine
gears.
what the AWW is. And because this claimant had no expectation of wages after March 20th, 2021.
I think we understand that
There's no
argument.
average weekly wage. So there's that and the medical opinion.
I'm trying to ask you an important question.
I'm sorry.
If we accept the judge's conclusion that there's only about 4 or 5 days that there may be testimony that he was completely off work, if that's the case, why would those benefits have to be paid considering 440.12, which says you have to have at least 7 days, missed days from work, before those have to be paid? Was that ever raised or discussed at the hearing that 440.12 would have barred, even if due, would have negated the timeliness of payment of those benefits?
That was not raised. That was very interesting. The judge, first he went into the AWW, and then he said even if there was an AWW, there would only be 4 or 5 days, and there was no mention of the first, and no entitlement to temporary total disability benefits because it was within the first 7 days. And there really was no need to, because there was no average weekly wage. I mean, now there's 2 defenses. There's no average weekly wage, and it's within the first 7 days.
Well, I'm not, does that have to be preserved, or it's just statutory application on our part?
No, and I didn't put that in my answer brief besides,
When your client accepted compensability, at least for the medical, what was the injury that your client was accepting compensability for?
compensability of the accident, which is the...
Which is what? What was the accidental injury?
Atrial fibrillation.
Okay. And how was that
Arguably
an
an occupational disease, and then...
So you acknowledge that it was an occupational disease, the
Pursuant to the
atrial fibrillation?
statute, he has a presumption that it's an occupational disease, and quite frankly, in my experience, there's no point in fighting that legally.
So if it's an occupational disease, it
According
presumes...
to Judge Arthur, that
Right.
was his take on it.
Which means that he suffered disablement as a result of the impairment caused by the heart disease.
Well,
Right?
it is one of the many forms of heart disease, atrial fibrillation. It is
Sure.
caused by a faulty,
Right, I
like a
mean, I know,
starter.
I get it. I mean,
Right.
we're not, I'm assuming there's not dispute that this was heart disease in some way.
right.
But the statute,
Fortunately, not one of the more serious of the heart disease. My son-in-law, first responder, had atrial fibrillation, had the surgery, been fine for decades.
but for the presumption to apply, which sounds like you acknowledge that it does apply, there has to be an impairment caused by the heart disease, right? And that impairment has to result in a disability.
According to the medical evidence,
Well,
that's-
according to the statute, that's what the statute says.
according to
The statute, 112.18, that's all part of the presumption. So for the presumption to apply, and the presumption is, was the impairment, or the disability actually, attributable to something at work? That's the presumption ultimately. And you've acknowledged that the injury or the accident was the actual atrial fibrillation, I guess, which then resulted presumably, because you said it was obvious, that when he was in the hospital at least, he was suffering disability, because who can work when they're in the hospital, right? So I'm still trying to piece together your position into a cohesive whole under the statute. If your client acknowledged that the presumption applied, that there was compensability, at least with respect to the medical, and it was based on an occupational disease in some way, all of that presumes that there was a disablement, which means an impairment of his ability to earn wages for a certain period of time. So where's the dispute over disability? And if there's been a disability, how can that I guess the lost wages, so to speak, or the compensation for that disability be zero? What's the basis for saying that there was a disability in the first place, I guess is what I'm asking.
Well, because there are several different articles to be, elements to be entitled to temporary total disability benefits, which was the claim here. There's different elements. And
I think
one of the elements is that there was an expectation of lost wages. And I think that's the big issue here. For this claimant, there was no expectation of lost wages. He did not have a job. He had not had a job prior. He did not have a job that he was scheduled to appear at in the next day. And so there was no lost wages. He was not entitled to temporary total disability benefits. Because there was no expectation of wages, there was no average weekly wage pursuant to statute or a fair and reasonable method for the JCC to calculate an average weekly wage. Although I think it's interesting that the JCC, in his amended final order on page 6, footnote 6, he does mention that the appellant had returned to work at the time of the hearing, but there was no evidence presented of his wages that he was earning. So could that have been a fair and reasonable way to calculate impairment benefits? Now, the JCC seems to include that in the discussion of impairment benefits because I think there was really no expectation, there was no lost wages because there was no expectation of earning wages.
Couldn't you be consistent in your argument by saying, I acknowledge we bought compensability of the claim by, accepting it. We just said, yep, there's been disablement. Why wouldn't it be consistent with your position as an employer carrier to say, yes, his average weekly wage is based on that employment that we've conceded all of the work connectedness, but our argument is that he's voluntarily limited his income or failed to look for work, et cetera, therefore discounting or zero, nullifying the average weekly wage, obviously except for temporary total disability benefits. But wouldn't that concept and position be consistent with what your client's trying to say? Instead of saying it's zero average weekly wage, it's the average weekly wage applies, but we still have mitigating factors to argue, such as voluntary limitation of income on the backside.
Again, the issue is the expectation of lost wages, whether he was really expecting income during that period of time that he was disabled. Here, there was no expectation of income during those period of times, and the first DCA and prior cases have called this scenario where there's an argument that, hey, even though he's not working, has no expectation of working, wasn't working, a windfall or unjust enrichment. And that is what I would argue in this case, where the appellant voluntarily resigns from his job, takes his pension, is kind of enjoying life, although he said there was some health problems he was dealing with. And then he has this atrial fibrillation.
Counsel, your time's expired. Can you briefly conclude?
Thank you,
Thank
Your
you.
Honors.
Madam Clerk, will you allow 1:50 additional time for the appellant, please?
Please, the court, a couple things on rebuttal. First, the employer carrier's point that there was no expectation of lost wages in this case. Here, Mr. Guglielmo did in fact find a new job, and he did in fact miss time from that job due to the compensable injury, which I think further supports our position that there is disability and there is entitlement to at least temporary total disability benefits. In addition, I think, or the record demonstrates that he was making a similar wage at his new job. So taking a look at the contract rate of hire for his previous job at the Department of Corrections actually does pretty well align with what he was making in the future. There was testimony at the final hearing as to how much he was making at his new job. He couldn't recall the exact number, but testified that it was between $10 and $15 an hour. And I believe at the Department of Corrections, he was making about $16 an hour. So I think, particularly in this case, using that contract rate of hire is the most equitable, the reasonable and fair estimation of his probable future earnings. In addition,
How much does what's your response to the appellee that your client wasn't, I guess, trying hard enough to find a job, and somehow that undercuts his claim for wages? I mean, you address it at the end of your brief, and that the 5 days is not supported by the evidence, but just generally under the law, like, how much does the claimant have to prove to show, I guess, beyond just the time that, I guess, the fibrillation occurred?
I think the voluntary limitation of income argument would be pertinent to a temporary partial disability claim, but not so much for a temporary total disability claim, at least in this circumstance. He was looking for work. I don't think there is a set standard on exactly how you determine what's reasonable when somebody is looking for employment. But in this case, the claim was just for temporary total disability benefits and impairment benefits and not temporary partial disability benefits. And I don't believe there's any evidence in the record to support a temporary partial disability claim.
If we were to, hypothetically, if we were to say, okay, we agree with the judge that, 5 days of TT are due, and I mentioned 440.12, which says that, if less than 7 days are due, it's not right due and owing for payment until the claimant has missed 21 days and then it goes back. So they haven't argued it, the employer carrier. Is that, although it's a statutory declaration, is that something they had to preserve below, or would you regard that as a right due and owing argument that they also failed to preserve, separate and apart from a statutory argument?
Right. It would certainly be our position that they failed to preserve that. Obviously, the law is that you don't get paid for those 7 days until you've missed 21 days. But in this case, the judge found entitlement to those temporary benefits, but found that it was worth $0. So in this case, I do believe that it should have been preserved, and the appellees did not cross-appeal that issue. So I think if this court were to reverse and to remand with instructions for the AWW, I think those 5 days of temporary total disability would have to be paid by the
Do we have to
employer.
remand for the average weekly wage, or?
I don't think so. I think no, Your Honor, I don't believe so.
Wait, you want us to make the determination as to what the AWW is?
No, I mean, I think if this court were to reverse and say that the $0 AWW is incorrect, there would be no other choice for the judge of compensation claims but to find a reasonable and fair average weekly wage that wasn't 0.
Which would have to happen on remand, yeah? I mean, it has to go back to there's work to be done still for the JCC if we were to vacate the FCO, right?
Yes, Your Honor, but not only, it's not just these issues that are presented today that are really they are, of course, all the issues are significant to my client, but the real concern is that if he were to become permanently and totally disabled as a result of his heart disease, or if he was to suffer some serious impairment, the primary goal, regardless of whether or not it's a remand or a reversal, would be that we don't want that $0 AWW, because that could create
Well, isn't it your argument, the average weekly wage is when he left work, his last day of work, what he was making? Or is it your argument we use for 4014D and you come up with a fair and reasonable?
I think a fair and.
I thought your argument was it was based on the 13 weeks prior to his last day at the department,
Right.
right? Is that not the average weekly wage you're claiming?
No, our argument is that the contract rate of hire, so,
You mean at the school where he was a security officer?
no, so at the Department of Corrections.
Right.
I think there are various ways that a judge of compensation claims could conclude what a fair and reasonable AWW is. I see that my time is expired, so I will leave it at that, Your Honors, and request that you
Thank you.
reverse and/or
Thank you.
remand.
Thank you. The court is in recess.
All rise.